There are two individuals or entities on Blue Jeans, Veterans in Politics, and I believe our Nevada judges. After some of our hearings, I've been able to log into YouTube and see video recordings of our hearings posted on YouTube on this case, and I would just ask the court to admonish those who are watching that it's not permissible to record court and then post it on video.
Case number 14, C348747, State of Nevada versus John Woodruff.
Good morning, Your Honor. Michelle Jobe, bar number 10575 for the state.
Good morning.
Good morning, Your Honor. I'm sorry, Judge, my camera's not on.
That's okay.
Your Honor, Louis Schneider. I'm sorry, Judge. Louis Schneider on behalf of Mr. Woodruff. And we're on for my motion today to transfer him to Veterans transfer him to the Veterans Court program.
They believe, is that Mr. Woodruff on as well?
Yes, Your Honor. He is present by Blue Jeans, as am I.
Request, okay. Your Honor.
Say that again.
I have a preliminary request.
Okay.
There are two individuals or entities on Blue Jeans, Veterans in Politics, and I believe our Nevada judges. After some of our hearings, I've been able to log into YouTube and see video recordings of our hearings posted on YouTube on this case, and I would just ask the court to admonish those who are watching that it's not permissible to record court and then post it on video.
Do we have someone from our Nevada judges on?
Alex here. Really frustrating, guys. First off, this prosecutor doesn't know what she's talking about. There are Supreme Court rules, SCR 230, and also there's a case called Solid v. 8th Judicial District Court that does allow us to record and publish these proceedings. The only thing that I wish I could do is actually let you guys hear my responses to the court, but when these attorneys make these objections like this without giving me advance notice or any warning, I don't have any way to set up my software to actually pick up my own voice. Right now, it's just screen grabbing the proceeding, which is pretty standard for our Nevada judges. And so when I speak, it's not picked up by my computer. And so I'm going to have to give you guys my responses right now after the fact in editing. Again, I really wish I could just give you guys the actual responses that I gave the court. But unfortunately, the software just doesn't record it unless I prepare it in advance.
Any response from the state?
I don't believe I was served with it. I will find it and file a motion about it.
So basically, I just told her and the court that we had two media requests that were approved, not only by this judge, which is the criminal judge, but even by the family court judge who was presiding over the CPS / abuse and neglect / DCFS, whatever you want to call them, proceedings. So she's complaining that she hasn't been served. This isn't the first time I've heard this. They aren't served by the press. We are not adversaries. We're not their enemies. We are non-parties. We file a simple one-page piece of paper with the court, and then the court on its own gives notice to the attorneys. So a lot of times these attorneys will complain that they haven't been served when they don't know what's going on, and she just doesn't have a clue that it's not a part of the process for us to file anything. So anyway, she can file an objection if she wants to. It's not going to go anywhere because the Supreme Court rules are pretty clear that proceedings that are open to the public are presumptively authorized for electronic coverage, and we followed all the rules, so we should be fine going forward.
Oh, let's see. Yeah. Back on, let's see. March 11. So certainly subject to any motion work going forward, but I did on March 11 sign and authorize the media recording, media requested an order allowing camera access to court proceedings, which I would note is fairly routine. There's no order sealing the proceedings, is there, Ms. Jobe? Or?
No, Your Honor.
Okay. So certainly our Nevada judges is permitted to record the proceedings, and the court would note, generally speaking, the court is open to the public, including media, if there is an order, and there is here. So Okay. Um, so next up, substance wise, we have the defendant's motion to transfer to veterans, amended motion to transfer to veterans court. And this is the one you filed February 17, Mr. Schneider?
It is, Your Honor.
Okay. Is there any opposition from the state to it, or?
Your Honor, I filed an opposition. I didn't file an opposition to the amended. All it did was include exhibits that were missing from the first filing. But I did oppose.
Your Honor, I'm actually a little surprised that the state is opposing this motion because Mr. Wilson was on Veterans in Politics show and he said,
Well, hold on, because I sorry to interrupt, but let me poll because I saw the amended motion filed February 17. And I know it had been opposed before, but that doesn't necessarily mean it's being opposed now. But in other words, now I need to refresh my memory before we go forward. I did glance at it, but not probably as thoroughly as I. Okay, so the exhibits are records, right, of service and benefits.
yes, Your Honor.
Okay, let me pull up the state's prior opposition. So candidly up front, this is probably something I'm going to need to take under advisement, but welcome arguments began with Mr. Schneider.
Thank you, Your Honor. Your Honor, I was stating that Mr. Wilson has publicly stated on the Veterans in Politics radio show that anybody that would be admitted to Veterans in Politics would be admitted to the Veterans Court program would be transferred to that program. And that's why Mr. Sampson from Veterans in Politics is here. He did that interview. Judge, just briefly, my client served with the 101st Airborne and in conjunction with a Special Forces team in Afghanistan. He saw 8 months of daily combat action, and obviously he has his combat tab. Your Honor, my client has been diagnosed with PTSD as a result of that service. And Your Honor, that service doesn't give my client a pass, but I believe it gives him some consideration when he served this country. Your Honor, I believe that my client would be best served being transferred to the Veterans Court. And I'm asking you to do that, Your Honor. As I said, he's been vetted. He has been accepted to the program. They've checked it all out. If the court has any questions beyond that, Judge, I'll be happy to answer any questions.
I probably do. Bear with me here. Yeah, so maybe a couple. So the state in their opposition says there's no jurisdiction because we, typically in these cases we'd have like a guilty plea or, finding of guilty at trial, but we don't have those. And so the state argues there's no jurisdiction. How do you address that?
Well, Your Honor, I did not set up the Veterans Court program, but the courts did, so it's a little bit above my pay grade. I don't know how that works, quite honestly, Your Honor. I just know that the Veterans Court program has been in effect and working, and I suspect that those questions have been answered, but I don't know, Your Honor. I was not involved in it.
Okay, and then the deemed appropriate letter I think you're referring to, but correct me if I'm wrong, was the November 17
I've got to check, Your Honor. So my client applied for the court program. They checked out his DD 214. They interviewed him. They looked at the case. They're aware of the entire case, and the letter is dated November 16 of 21. Status of application to Veterans Court Treatment Program, Your Honor.
Okay, and one thing that I saw right away, reviewing that letter because it's been some time since I did, says acceptance valid for 60 days. Seems to me we're past that point, or
We are, Your Honor. I checked with them. They said that they would extend his acceptance to the program. I think if I recall, the court was ill at the time and we had to continue this matter. And then Miss Jobe was out of the country, I think, or at least out of the jurisdiction for some time. And that's why the delay.
okay. Thank you. So you'll have a rebuttal, certainly if you want, but let's hear from Miss Jobe.
Thank you, Your Honor.
Your Honor, Veterans Court is established under Chapter 176A of the Nevada Revised Statutes, and the title of that chapter is Probation and Suspension of Sentence. We are procedurally premature to be discussing whether or not the defendant should be accepted to Veterans Court. Whether someone's accepted to Veterans Court and should be transferred to Veterans Court only comes into operation when a defendant is standing before the court pending sentencing, and it's discretionary. There's nothing mandatory. And the state's position in each case about whether or not someone should be admitted to Veterans Court is a case-by-case basis. But I'm not here to argue the merits at this point in time because that is an issue for sentencing. At this point in time, the motion should be denied, and it should be revisited if and when there is a conviction or a guilty finding against the defendant.
Thank you. I understand very much what you're saying. That's why I asked Mr. Schneider the question procedurally. I'm pretty sure I've never had one like this. So the argument is essentially there's no jurisdiction, at least at this time, because there has not been, a plea or a finding of guilty or anything like that. Is that a fair summary?
Yes, Your Honor.
Thank you. Mr. Schneider, any rebuttal?
Honor, I have had dozens of clients transferred to Veterans Court program, and it's always at the early stages or mid stages of the case, Your Honor. It took some time in meeting with my client and finding out that he was a veteran. The court was not notified in advance, but I have never had a case transferred after a trial or a finding of guilt of any kind. It's always early on in the program, and so I would ask the court, and I know you're not supposed to do your own research, but I would ask your court to speak with the Veterans Court program and see what they have to say about that.
Yeah, thank you. Actually, that's kind of so you would have no objection with me contacting the Veterans Court program outside your presence?
No, Your Honor, none whatsoever. Absolutely.
Ms. Jobe, any objection to me contacting the Veterans Court program outside your presence?
No, Your Honor, I just reserve the right for the state to make any arguments or discussions about the appropriateness of Veterans Court in this case.
Okay. Let's do this then, because my familiarity is much more with drug court, mental health court, co-occurring disorders court, and it would behoove me then to contact Veterans Court to see here. Let's see. So what I'm thinking is I do that and bring you all back in, perhaps for additional argument, if any, once I let you know what was said there. Does next Thursday the 21st work, or if that doesn't work, does Tuesday the 26th work?
The state would request the 26th. I anticipate being in trial, and I would just request that the court also look at the language in NRS 176A.290.
Oh, sure. Yeah, I'll be doing that as well, certainly.
The 26th works for me, Your Honor.
Okay. So continued hearing on the pending amended motion for Veterans Court, April 26th. Ms. Clerk, if you know, remind us, will we have all hearings at 8:30 by then?
That's correct, Judge. They will be at 8:30.
Yeah, so council, we're going back to all hearings at the same time. So April 26th at 8:30.
Thank you very much, Your Honor.
Thank you.
Thank you all. Thank you.
Have a good day, Judge.
You too.